Peace to the gods, peace to the gods. Yusef here. What up, what up, what up? Apologize for being tardy. I was up till 4 o'clock in the morning. I was reading, and I'm gonna share, the research that I was doing last night. I've been doing some very, very serious research. And the reason for that is because we're on the brink of a world war. And I think we need to start paying attention to what's going on in Palestine between the Palestinians and the Israelis. It is very important for us to pay attention to that and have some background understanding of exactly what is going on in that particular situation. So I'm going to talk about that a little bit. But today, I'm going to do another court review. I'm going to be looking at some of the Moorish nationality defenses. Now, I want to preference what I'm going to say. First and foremost, this is not an attack on the Moorish Science Temple. I have nothing against the Moorish Science Temple. I'm just doing reviews of every particular type of situation. There is a lot of truth and credence to a lot of the things the Moors say. So, I'm not here to attack them. I'm not your enemy or anything like that. I know some people, they come up, he's dirty Moor, and then, start calling me names and stuff like that, and that's not the situation here. I'm actually, in the first case I'm going to look at, I'm just going to be pointing out how because I do a lot of these, I do a lot of these shows. My first goal is to show you how they use deception in the court. It is not to attack the litigant or the defendant or the pro se who is in the, that's not my goal. That's not my intention on any video that I do. On any video I do, I'm not looking to attack the litigant. I'm going in because, listen, this is my niche in this space. You got people out there teaching you how to discharge debt, how to get, a Treasury Direct account, and all these different things out there, and that's fine. I've been doing this a long time, and what I see is the problem in this space is people don't have a knowledge of the fundamentals. So I'm trying to fill that void. That's my purpose, to fill that void and show people, give people a deeper understanding of what is going on. If they want to branch out from that and start studying other things and learn other things, that's fine. But hopefully when you're over here, you can get a solid foundation of this information. And I think it's beautiful that we're in a time where we have the internet, and as a result of COVID, they start conducting a lot of these proceedings on the internet. Now we all get to look. It is so many. Now, this is another thing I want to say to the other gurus who are listening. All right. There's an army of attorneys and other people out there making videos to make people look foolish. Why am I the only person on the front line? If you want to monetize your channel, this is an excellent opportunity to do it. Pull up some videos and start doing video reviews. It allows you an opportunity to demonstrate your expertise and your knowledge on this particular subject. If you want to know the software I'm using, I use Wirecast, and I have a green screen that I got off Amazon that allows me to, Wirecast is a beast program. It is a real nice program. I use Wirecast is the name of it. And I have me a Rodecaster Pro 2. I have 3 Rodecasters, and I have me an ATM Mini Pro. That's my video switcher that allows me to switch through cameras. And I have 2 Sony 4K cameras. That's all the equipment I got that I'm using, And I've been studying this Wirecast, and it's so many things that this thing does. I was using 2 computers at first to show people stuff on the internet, but Wirecast, I figured out how to do it just Wirecast. And it's like, wow, this is a very nice program. And so I'm just giving you that information so you can, if you want to, start doing live streams and you want to start doing video reviews, you can do it. I think I think probably with everything I spent, how much I spent on everything, camera 1,000, 1,600, 2,000. I mean, just Mike, I'll probably say under $3,000, is what I spent on everything, to get things going. All right. So, it was a worthy investment, make the investment. And I think I'm going to do some videos and show y'all how to make audiobooks and things like that too, because we need more people. I'm by myself. I can't do all this by myself. There are 350 million people in the United States. Okay. I only got 50,000 people on this, about 60,000 subscribers on my channel. I had almost 90,000 before they took my channel down, and I built it back up to 60,000. So hopefully I can keep that going. The groups, if you're on SBC University, somebody said SBC. Let me show you that real quick. Somebody's asking me a question. Say, I can't find X, Y, and Z. All right, so go to let's look at something real quick. Yeah, you're new. That's why I'm doing what I'm doing, because I know we got a lot of new people. And it's new people coming into this space every day. And the first thing, when you're a new person, first thing you come in, you run into somebody saying, yeah, you can get your TDA account and discharge your debt. It's like they don't understand anything. They don't understand public and private. They don't understand what happened in 1933. They don't understand a lot of different things. So, we need some sort of space where you can come and get a foundational understanding of everything. So real quick, let me, okay, this is SBC University. This is my website. When you join, as soon as you log in, you're going to be taken to the dashboard. Okay, the dashboard is where it goes down. I'm adding some things down here. Just give me some time to get them connected. But right here, I'm adding a lot of stuff to the website. This is your secure party step-by-step training videos. I don't know why somebody said I didn't make professional videos. I put a lot of time and effort in making these. Are very professional videos that I've done. And you can see them. I have intros on the UCC introduction, copyright clearance, search, commercial security agreements, registered mail form, affidavit of tax, and I'm adding some more videos as well. All right, so just to give you an introduction to the secure party process. And so you get a good understanding of, of the videos. There's 26 videos right here. Okay, also, somebody just asked me about the groups. Where you down here, you can see the groups. Here's YouTube. Here's my Facebook group. You just click on that. That takes you directly to the Facebook group, which is Secure Party HFR. As you can see, we have over 24,000 members in that group. If you are watching and you're planning on going in my group being a troll, I don't give any warnings to trolls. I just immediately kick them out. As soon as I see a post, oh, show me this. Why are you doing this? This is foolishness. I just kick you out because you are forced to sign an agreement that you're not a troll and that you're going to abide by the rules before you come in. If you don't check that you abide by the rules, you're not getting in. I disqualify. So don't think that you're going to get in and you're going to come and not answer all the questions before you come into the group. You will not be allowed into the group. I'm very strict with this group. I have zero tolerance. And as soon as I see something, you are eliminated. The group is for the exchange of information and people are interested in this subject. I have to question, if you are a person and you're not interested in the subject, why are you in this group? Why are you in my group? Go somewhere else. If you're not interested, if you think it's foolish, if you think people are doing something stupid, then go somewhere else. Do not come in my group. The thing is that you're just mad. You think well, it just shows me that I'm some sort of threat, because you don't ignore me. That last video I'm doing, almost getting 40,000 views. I know that got to be irking you. I'm showing people getting cases dismissed. You don't like that. All right, so additionally also, we got my HFRN radio archives. This is where I started off with Blog Talk Radio. These are my archive shows, HFRN. You see right here, my boy, he's still over there doing blog talk. So we got archives, and these are actually the old shows that you see me posting on YouTube. They're already on SBC University, all of them. But every now and then I'll take one from here and just post it on YouTube, a radio show. But if you want to listen to the entire catalog of radio shows, it is on SBC University. You can go in. It's a ton of information. I mean, everything from dealing with third-party debt collectors, a lot of guests that I had on the show that had some amazing information. All of that is on there as well. All right. Then we have the live webinars. The live webinars are, you're going to click on this to join. I'm going to do a live webinar tonight. Okay. So you need to be on, and all you have to do is click on the button and join. It's going to take you directly to the webinar if you are a member of SBC University. Okay. All right. So that's tonight. You got to be a member. So you get to join a webinar for $49. All right. Also, I got an archives. The archives is all the old things that I've done over the years. This may be why somebody said that, you know, some of my stuff is not high quality. Well, it's not high quality because I got everything on here I've ever done. When I first started off, I didn't have good equipment, but I sold a lot of these webinars for years, and people were able to gain a lot of insight from a lot of them. So now, just from having a $49 membership, I was selling these like $150 a piece, but now just having a $49 membership, you are able to access every webinar that I've ever conducted. And I've conducted a lot of them over the years. All right. So that is something that you get for your $49 membership. Also, we got the affiliate dashboard that takes you into Currency Circulator. Currency Circulator, you're going to register here. And once you come into Currency Circulator, you're simply going to do the free registration. You're going to be put in a holding account. We're going to check to make sure your account is active, and then we're going to let you in, and that's where you're going to get some money. You'll be able to see the money that you get. I'm giving back that $49 that you're giving me, $25, your first $25 is going into that, and that is how you're going to, it's a community type of situation where every single person who joins has an opportunity to get some money. However, there are qualifications that you have to meet in order to receive a commission from here. All right. The next thing I want to talk about on the website is obviously we have dictionaries, we have templates. If you need templates, I got a lot more templates than this right here. But if you need templates on bonds, affidavits, there's a black card application, debt collection, documents, equity. I'm always putting templates on there for you to utilize. Okay. I think what I'm gonna start doing too is going and get the forms and pleadings book and just put a lot of those templates in there as well. That's a good idea. I think I'm gonna start doing that so you don't have to go to the law library. Also, I've collected gurus information from all over the years. All the gurus that I've had a chance to listen to: Aaron Cokes, Bill Cox, y'all already know who that is, Byron Beers, Creditors in Commerce, Chuck Eugene Farley, David Clarence, David McDowell, Ecclesiastical Depots, Eddie Craig, Gene Keating, Judge Dale, and I got a lot of my Pastor Tony King, which if you want to learn about the DTC and Treasury Direct accounts, that's what you should be studying. Patrick Devine, Tim Turner, Tim Turner. It's a lot more than this. I haven't gotten them all up here. I'm still like organizing stuff. But over the years, I collected information from a lot of gurus because I did like you did. I was watching a lot of the gurus, and hell, you want to look at their information, you should see, because you need to know where a lot of stuff came from. Like when, for instance, like I'll give you one that a lot of people don't know. A lot of people, you hear them talk about this all the time, but they don't even know that this man, David Clarence, the executor. Okay, yeah, I'm the executor of the estate. Well, that came from David Clarence. He's the one who brought that out. He brought all that information out, all right? And he has all the executor letters that he's ever written I got on this website. So if that's your forte, then hey, you go to it. Like I said, this is a depository for all. It's like if you went to a university, you got a library in a university with all your books. It's the same thing I'm doing over here. You got a library, you want to start studying stuff from other people, and everything is over here for you to study. I made that available to you as well. Let me get back to the, let me see, can I show you that David Clarence real quick? Yeah. So you can, this right here is ginger, honey, apple cider vinegar, and yeah, ginger, honey, and apple cider vinegar. It's good as hell. This stuff right here make apple cider vinegar taste good. I was like, wow. I hate the way apple cider vinegar tastes, but that right there, y'all must be a lot of people coming in. See all these executive letters and everything? Executive letter, executive letter, executive letter, executive letter. You know, this is where this came from. So I just like to, it's like I've been doing this a long time. So watching people come into the space and talk about things, and I'm like, they actually come on my page and tell me things like, you need to investigate State National. I'm like, are you really? It's Sovereign Defense Ministry. They got all that on their website. You don't think I've been over there and read all their stuff and everything? I don't put it on the website because they got mad at me and threatened to take my website down. I don't know why the Sovereign Defense Ministry got mad at me. I was just, hell, I give credit to everybody's stuff. But, a lot of people don't know who you are, but they got a lot of good stuff on their website. They got a lot of real good stuff on their website, the Sovereign Defense Ministry. But you can't point out something I haven't read or haven't studied. You don't have to tell me things. I've read a lot of different things over the years. I've been in court a whole bunch of times. I've been in court a lot of times, and on foreclosure, on criminal cases, things like that. So, fortunately, I haven't had to go back to court for a long time. And I like it like that. I don't want to be in court. So I try to conduct my affairs in such a way where I don't end up in court. And that's what you should be doing too. You should be conducting your affairs in such a way where you don't end up in court. That's why I teach the way that I do and tell people to use corporations and business and things like that, because the entire system is based off the premise that everything is corporate in nature. And that's what we're going to get to today with this Moorish defense, because the Moors, one thing I do take issue with them with is I don't think this has anything to do with nationality whatsoever. I've studied this for a long time, and I don't see how nationality plays a part in it. Perhaps if we were under a common law system, it may play a part, but we're not in a common law system. And I understand you're attempting to do what the last man did by saying that you won't want to be a part of their society. However, Noble Drew Ali incorporated the Moorish Science Temple under the Religious Incorporation Act up in Chicago, Illinois. So I don't understand. That's a benefit and privilege from the state. So it's kind of like, and then there are factions in the Moorish Science Temple too that you need to understand. I'm gonna do some reviews on some things that I took down, but I guess it's time for me to put them back up and just give you something to think about. I'm not saying I'm completely right. I'm just saying in my research, I don't see how nationality plays a role in commerce, all right? So we got business trust information. We got a ton of business trust information. The live webinar recordings, after a webinar is conducted, the recording is placed right here. All of them are recorded, and if you don't make the webinar, you can watch it on a replay, and that's where that is right there. So there's a lot of things I'm adding also. There's a download section that gives you quick access to a lot of PDFs. We got a PDF library, actually a huge PDF library with over thousands of documents associated with this. A lot of stuff on this website, tons and tons of information, well worth the value of $49, all right? So with that being said, let's get ready to rumble. What we're going to do first is we're going to get, the likes up. Let's try to get the likes up to 200 likes. Let's get the likes up. Let's get the likes up. Thank you for the donations. We're going to do a Moorish. And I had a couple of them, all right? I got a couple of them that I want to talk about. A couple of them. All right, and this is just one I just found. I'm not picking on anybody. I just put Moore's in Court in the search bar on YouTube, and I tried to go through. I just kind of did a cursory investigation of videos, and I just picked one that I thought might be, a good to talk about. So it wasn't anything in particular I was looking at. If you're the person that's in this video, I'm not singling you out or anything like that. You just happened to, I just drew a straw and your name came up. That's how, I picked the videos. There's so many on YouTube that, it's just, it's just a plethora of them. All right. So, all right, we got the likes up. Let's get ready to go. And let's see what we're talking about. Let's see what.
All right, Mr. McCreary, I'm ready.
I don't know how this stuff works. I'm new to this, so I'm
Okay, well, sir, hold on now. Okay. All right, this is case number 02-561-9901. The people of the state of Michigan versus Carnell McCreary. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCreary, your name?
Carnell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date.
Okay, I don't know why this judge. Now this right here, this is why I picked this out, because I want to study this judge. I didn't pick this video out because of the Moore. I picked this video out because of the conduct of the judge. Now you'll notice that they're trying to style the names now in the Christian appellation, Judge so-and-so, because a lot of people are catching on. That's what they do. You're going to have to get used to the fact that as information gets exposed, they try to cover information. The way the name is styled does not dictate anything. It's whether it's public or private. That's what dictates something. All right? They can write it however they want to. I don't give a damn if it's all caps name. For others to sit there and say they don't write things in all caps, and anybody can look on the caption of any pleading in all 50 states and see the names are stylized in all caps, on your driver's license in all caps, on your utility bills in all caps. Everybody in Congress nameplate is in all caps. Supreme Court justice is everybody. And you try to act like your checks on your checks that you get from the bank, your bank accounts, all caps. But you want us to believe that that's just a coincidence. A very wise man told me something once. He said, when 2 things happen, it's a coincidence. When you see it 3 times, it's a warning. Okay? So people are not foolish, ma'am. Now, you are here on a mission. You understand how he's coming. You're prepared for him. That's what I want you to see. This woman is ready for him. All right? She ain't getting surprised or anything like that. She's ready, and she's ready to combat him. This is an administrator. Now, they call themselves judges, but they're administrators. What makes them administrator? Because they're here enforcing statutes. Anytime a judge is enforcing statutes, they're not operating as Article III judges. They're not constitutional judges. They're not judges with lifetime tenure and protection from salary diminution. All right? Those are 2 qualities that are necessary, because a true judge has to be protected from any type of outside influence. He can't allow somebody to attack his money or his position. That's why they are appointed for life, and their money does not get protected. That is a real judge. If they don't have that, they're not a real judge. If they have a 4-year term, they have to come up for election. Those are not judges. They call themselves judges, but they are administrators. So this is what we're contending with right here, an administrator. And if anybody needs any evidence of that, if you're watching, I'll be more than happy to go into that. That's a very easy subject to address, whether or not these are judges or administrators. That's also the reason why we asked the question in court. So he started off by saying, I don't understand any of this. All right. And, and then he just, for the record, my name is not in all caps. And that's an appropriate response, because if I would have said I'm not that person, then all of a sudden you're going to issue a warrant and say, and for a failure to appear, and say I didn't show up in court. Because at first you weren't able to address that. When we say, I'm here concerning that matter, you didn't know how to handle it. You had your conferences, and then y'all came up with a solution. Okay, every time they come into the courtroom and say, I'm not that person, we'll just say, oh, well, he failed to appear. It's your warrant for his arrest, even though you're sitting right there in court. So understand, when they say that information changes and grows, that's an example. They do come up with defenses for some of the things you come up in court, but they're always procedural in nature. It's always procedural. They're going to get you on some sort of procedural type of situation. And that's what she's going to try to foist upon him, while all the while trying to ignore his status, his position, and the claims that he's making in court. Let's continue.
Set for a pretrial conference. And Mr. McQuarrie, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions with all due respect. May I speak?
I don't answer questions to counsel. I don't answer questions.
When I saw her say this is why I picked the video. They didn't come up with another way to try to circumvent things. No, you have to answer questions, ma'am. If I invoke the Sixth Amendment for the Constitution of the United States of America, okay, what you do with this judge right here, administrators, this is where you go get an administrator's oath of office. You can either get it from the clerk at the courthouse, which I wouldn't do, because a lot of courthouses, everybody in that courthouse is on a team. And you really taking a chance going into a courthouse asking for things. They'll give it to you, but once they know who you are, okay, you're going to start having problems in the courthouse. Anytime you want one of these administrators' oath of office and bond, you go down to the Secretary of State's office, because what? They are they're employees for the legislature. So they have that document and they have to give it to you. They are public servants. I want to see their oath of office and bond. Usually in Georgia, they give you two documents. All right, one is the oath of office, one is the bond. A bond is a promise. A bond is you giving your word. One is stylized in all caps, one is stylized in the Christian appellation of their name. So you bring that into the courtroom. I'm sorry, Your Honor, but it is my understanding that you have made a judicial determination and I'm not to be afforded my due process rights or freedom of speech in these proceedings. Well, it's my understanding, ma'am, that according to the Sixth Amendment, I have a constitutionally protected right to know the nature and cause of any action. And since at this point I'm confused, it seems to be the court is operating on some sort of presumption, I need some clarification. And you're speaking to the record. Understand that. You're not speaking to her. You're there making a record. Keep that in your mind. You're talking to her, but you're not really talking to her. You're talking to the record. You're making a record. And that's the game that's being played. She understands a record is being made. So they got to learn how to conduct themselves in such a way where they can use obfuscation or lift at different techniques so the record will reflect certain things. So that's the contention that's going on between the two, is you're making a record, because this can go to the appellate court all the way to the Supreme Court. And depending on how that record is conducted is going to depend on how it goes in the appellate and Supreme Court levels. So making a record is very important. Like I said, I had an attorney who's a friend of mine. He said, look, when I go out to buttfuck Georgia, he said, I'm not going, he said, and I'm going into a county where the sheriff, the prosecutor, and the judge is cousins. He said, man, I'm not going out there to win. I'm going out there to make a record. He said, I'm going to beat them on appeal. He said, and 80% of the people, they win on appeal. They actually win. They win on appeal. But how you win on appeal is going to be determinative of how you make a record. And we need to get into some discussions about that, because the appellate court is only looking at the procedural aspects of the lower court, unless they do a de novo review of the case. De novo means anew. That means they look at the case from the very beginning, which is they don't do that often on the appellate level, unless the circumstances call for it. All right? So she don't want to answer no questions. And that's okay, because silence is what? Acquiescence. Ask the questions anyway. Ask them anyway. Because the person asking questions is in control. And right now, she's trying to take an assertive stance. And they always get black women to do this. Have y'all noticed that? They get a black woman to indict Donald Trump. They always get our black women to do everything to attack their own. Because they mad as hell, they angry at men and all kind of things like that. They just use them almost like they're bed wenches or something like that. I'm going to be talking about that at length, too, of how they are utilizing our women against us. And I don't know if you've been noticing that lately, because black women, a lot of times, because of their nature, they make some of the best, I hate to say it, almost like the best guard dogs. They kind of do, you know? So understand that, okay, the contention of what's going on right here, all right? Let's keep going.
That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McQuarrie, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date, but otherwise.
And this is something I take issue at. You can file an oral motion. Okay, they got something called ori tennis. I want you to write down this word. Ori tennis. And it's it means by mouth. Okay, let me see if I can pull it up on the screen. You see it right here, ori tennis. Testimony. Evidence presented ori tennis, what it means, by mouth. Okay, you don't have to file a motion with paper. You can move the court orally. You know, so this right here, I don't, you know what she's saying, and here's the next thing, you're not even filing a motion. We're not even trying to get to a motion, Your Honor. Let's look at some things. This is what I'm trying to do, Your Honor. This is what I'm trying to do. Now, this right here is on SBC University. You do not have to be a member to access this page. You can just go over to my website. Don't have to join or anything. I got all these things right here. You can just download. This is just free for anyone who is watching right now. I got a ton of things over here, and I'm adding things all the time. All right, so right here, we got the document. I'm always talking about it's abatement at common law. And in here, we got a phrase that you can say in court. Right here, you need to commit this to memory. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I'm therefore unable to enter a plea to the charge, and until I've had an opportunity to raise a meaningful defense against these elements, I cannot rebut an unstated presumption. All right, so they're operating off of a presumption. This is why you're doing an abatement, because they're skipping over process. In other words, first of all, we need to make a determination whether or not you even have an impersonum jurisdiction. Okay? We need to know the nature of the action. They used to announce the nature of the action. They don't do it anymore. Is this common law or is this admiralty? You know, we do have common law. It operates under the common law. We're in court. I got a right to ask you that question. Is this common law? Is it equity? Or is it admiralty maritime? The Constitution lists those jurisdictions. You did take an oath to uphold the Constitution for the United States of America, or are you a traitor? And we know what happens to traitors. And that's what a lot of them are afraid of. Because a lot of people have committed treason against the United States. I want y'all to understand something. Your government has been taken over by Marxists, communists, and socialists. They've taken over all your universities. They call them liberal. That's the name they use, liberal. They've taken over all your universities. That's why all these young people are coming out talking about identify stuff, LGBTQ. You see these girls that started LGBTQ, they were lesbians and they claim to be Marxists. Okay, there's a lot of people right now, they ask me, well, what's wrong with socialism? They don't understand. They saying, well, the capitalism is the problem. That's Marxism. Marxism is an attack on capitalism, where there's never been an example of socialism working anywhere in the United States, in the world. And the reason they're taking over, and we're going to look at Mem Koff, My Struggle, which is Adolf Hitler's document, and we're going to do it today, because I want y'all to understand what's going on in Palestine. And the reason we're going to read that document, because I want you to see what this man is saying, and I want you to decide for yourself of what was going on in Germany. Is it going on in the United States today? Or is this man just some sort of demon, hateful individual like the Zionist media want you to believe? Hitler is not looked at as a bad person in the other parts of the world, especially out in Germany. They just passed a law in Germany. They won't even allow them to say his name in Germany. And they put Jews in control over there. Just like in Ukraine, the president of Ukraine is Jewish. He's an actor. I think he owns OnlyFans. OnlyFans makes $56 million a month off of the OnlyFans models, and y'all sitting there done saying that y'all don't have to answer to no man, and that man right there is the biggest pimp on planet Earth. But y'all want to talk about Andrew Tate. I think it is laughable. You getting pimped, dear. And I ain't mad at him. I'm not mad at him. Hey, pimping ain't easy. But anyway, so that is the question, what we're trying to determine. We're trying to determine the nature and cause of the action. That is always the question. Understand they are watching this video. Understand they're going to be ready for you. Understand that they have conferences and they talk about what's going on in the courtrooms and they come up with ways to circumvent what you're doing. Understand that. Don't be an idiot all your fucking life. Let's continue.
I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court, with all
You're
due
going to be
respect.
restrained every time you go off course. So
Well,
understand.
Okay. This is one of the techniques that they talk about in Court Survival Guide. So let's look at that real quick. Court Survival Guide. Now, I hope y'all know I'm stopping the video because this is a class. If you want to go back and watch the entire video, you can at a later date. But this is a class. I'm teaching class right now. I used to do this a lot. Use video in my seminars. I used to use videos like this to teach class with, to show people things that you don't see. Interruption. Interruption is a technique. Interrupting you. Excuse me, Your Honor, but I would appreciate it if the court would extend the same courtesy to me as I'm extending to this court. Now, I'm attempting to make a record for appellate purposes, and I'm unable to do that if the court keeps interrupting me. All right. So interruptions, you can find that in here. I'm not going to just go into it, but you can find it in this document right here. It's called Court Survival Guide. This is a very, very good document for you to read. It gets into some very, very good techniques that are going on into the court. This has been going on for a long time. The thing that it's going to show you, they've been using the same techniques and strategy for the last 30 years, y'all. It's not new you just new to this space and you're just coming into it, but they haven't changed much. The only thing that I really just see that they really just changed is that name thing. When you come in and you don't want to answer to the name, that's the biggest change that they made. But a lot of the other things, they're doing the same thing they've been doing for the last 30 years. The same thing. Ain't nothing new. They're not doing anything new. You read this document right here was written in, 2008? That's 15 years ago. And you can still glean a lot of important information from this document. Right here, let's read a couple of things real quick. The playing field. You are in a rigged game. You are the visitor and playing without the home field advantage. You can forget about truth and justice as these have been eliminated. The only way you will win is by embarrassing the court. This is a cash register court with absolutely no vested interest in proving your innocence. They just want your money and your obedience to the rules, which take your money. The deck is already stacked against you. Just by your showing up and being there, you're already convicted and presumed to be guilty. You've already been treated as guilty by the arresting officer, and you've been proven your guilt by signing the ticket. The judge and the prosecutor are both playing together against you. They have both taken a secret oath to work as agents for the foreign banks in their effort to maintain control over you and your money. The game, as a minimum, will be interesting, challenging, and educational. Playing a game. There are many strategies, tricks, maneuvers, and legal points to argue about that are good to know. Currently, we would go for the best strategy at the first appearance, getting a quick dismissal, and avoid having to fall back on the rest of them. And how you play the game will affect how your opponents play and vice versa. Since their jurisdiction over you is conveniently implied by your unspoken consent, it must be challenged right up front so that you'll be able to stand on the Constitution and maximize your chances of early dismissal. Otherwise, very few of your other strategies will work well. Not all of the factors will come into play in every court appearance, especially in the initial stages of your case. Some of the rules apply to some hearings and some will apply to others, and as you will see. But here are some basics that you really should understand for any such appearance. You got to know what your rights are, and I'm not going to go through that. Here are a few general psychological tips. You are Mr. Nice Guy, always polite, diplomatic, and courteous. If you lose your temper or clean language, you will lose the case. You are a very smart sheep going into wolf country. Number 2, you can say anything you want in court under the First Amendment, but the more you say, the more you risk. Better to ask questions. That's why she says she's not answering any questions. Because anything you say can and will be used against you. That's a principle. It applies to them just like it applies to you. They don't want to answer any questions. And they're going to use this false authority by getting, all that meanness, all that bravado that she's doing, that's a technique. I'm not here to answer any questions, sir. We're here to do procedural. I'm like, whoa, baby. You got to maintain and just remain calm. Identify what is going on. See, you can't fight against it if you can't perceive it. See, a lot of you will see things and get emotional and start saying, Judge, they just ignored everything I was doing, Yusef. I went into the courtroom and did exactly what you said, and it didn't work. Because you don't have eyes to see and ears to hear. You're just doing what somebody told you to do. You ain't looking, paying attention. You're not perceptive. Every situation is different. I can only give you general information. Let's look next. The judge and prosecutor working together against you. You will see how they cover each other's butt. The judge is supposed to be just a referee. Sometimes you can catch the prosecutor coaching the judge along and trying to control the judge's answers, and you'll find that a lot. Sometimes the prosecutor is more knowledgeable than the judge. I had seen that on the federal level. Shocked the hell out of me. Whenever the judge or the prosecutor is overly polite to you, it means that they want something from you very much. I remember I had a prosecutor came into court. She came over trying to talk to me, shake my hand. Anytime you see that, you need to be on full alert. They are not your friend. That is a technique, being nice to you. Let me tell you something. Let me stress that. That is a technique. Ain't nobody your friend in that courtroom. I don't care how they acting. You there to conduct business. And this is what I said about being a businessman or woman. This is business, and it's no nonsense. And to give you an example of what I'm talking about business, I'll give you a little light example. When I first started my real estate investing career, I was doing flipping houses. And one of the first people I flipped with was a husband and wife team. And so, you know, the husband, he was the one, he went out into the field and found the houses, repaired the houses, and did all that, while the wife, she handled all the money and all the business and everything, the contracts, the money. She did all that. They had a very good team, husband and wife team. They were a beast. So when I met the husband, we was yeah, man, blah, 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 kicking it and everything like that. And then when it was time to get to the table and conduct business and sign the contracts, I had to deal with his wife. And I tried to carry that same energy to his wife, and she was like, can we get to the business right here? Can you get the contract, sir? Wasn't none of that laughing and giggling. And I'm going to be honest with you. Women, and that's why they use women, women are better at maintaining a certain professionalism in business, I think, than men are, which is why they do put them in certain administrative positions, because they are no nonsense with a lot. I use women, right? I use all women. I use no men. I use all women, you know, because they no nonsense. They handle their business. They do a lot of stuff better than men do, you know. So I will agree with that, because men, you know, they want power, they want prestige. You know, we just not really conditioned to remain subservient to another man for a extended period of time. You know, especially someone who's very ambitious. But just saying, all right? That's why they say, you know, women who are ambitious are very masculine acting. But that right there, let's go to another one. All right, so be wary when they're polite to you, okay? All right, let's go to number 6. The judge and the prosecutor both know that although the hearings are taped, only the transcribed written record is admissible as evidence in a later hearing. You can suspect that they will try to get you to believe something or communicate some lie or manipulation that will not appear on the written transcript. The transcript is important, the stenographic record of the proceedings. That's the skill you have to learn you have to learn how to make a record, man. They know how to make a record. They understand all the nuances of law, how silence is acquiescence, how you have to ask for something 3 times, how when you form an objection, it has to be sustained or overruled. And if they don't say that, how you have to form an exception. I take exception to the honorable judge's refusal to rule on my objection. Would you please enter sustained and overruled into the record, ma'am, so I can preserve the error? When I say preserve the error, I'm talking about reversible error, because you've done something on the record over my objection that, you know, could something like hearsay or something like that shouldn't be admitted, but you admitted it anyway, and I want it pointed out on the record, so when I take it to the appellate court, they can point that and highlight that point. All right, let's keep going. The judge is conditioned to hear grossly distorted versions of reality from opposing viewpoints from the attorneys, liars, who in turn expect the judge to rule in their favor by making the other attorney appear to be the bigger liar. And you got to understand that too. That's why you always remain silent and ask questions. And anything you say can be and will be used against you, because you can't make another person interpret what you're saying the way that you want. You can say something to somebody and they can interpret it how they want to. You got to be very careful what you say on the record. It's called an inference. If I say something, you say, you know, and a lot of women do this. A lot of these feminist women. Oh, so you believe in abusing women? I didn't say I believe in abusing women. You know, I said they'll just take something to just twist it around and hear a grossly distorted version of what I just said. I didn't say that. You'll find that a lot because they're hearing what they want to hear. And that happens a lot in court. And you have to master the technique of narrowing things down to specifics, because law is a science. And just like in a laboratory, nothing can be left to chance. Like I told you on another show, I was watching this video, this movie where it was this husband and wife team. He was a surgeon and she was an attorney. And he was kind of looking down on her profession because he was talking about how much precision is required in surgery. And she just retorted back, it requires that same sort of precision in my profession. And she was not lying. And you'd be well to listen to what I just told you right there, because that is another problem with a lot of people that I see going in court. You don't understand this is a science. All right. Let's get back. Let me see right here. Right here. Let me just jump down right here. The judge is very good at avoiding questions when you put him or her on the spot, so you must be even better at steering the judge with your questions into a corner. The judge will try to convince you that you're in some regional court or statutory jurisdiction or other such nonsense. This is entirely false in this case. The court is operating under color of law, namely phony, because it is using another name for its obvious admiralty military jurisdiction. Just look at the gold fringe on the flag. It is also fraudulent because it is operating outside of its geographical venue, defined as 10 miles square of the District of Columbia. That's not true. That's not true. That's not true. You need to read Article 1, Section 8, Clause 17 that talks about their jurisdiction. But what you have to understand, territory is forts, magazines, District of Columbia, also these federal court systems, Federal Reserve, post offices, but it's also that Social Security number. That Social Security number is their territorial jurisdiction. It's the biggest one that they got. That's why we call it a franchise. It operates outside of the District of Columbia. Just like a lot of banks have their home office in North Carolina. Okay, well, you know, Bank of America, I believe its home office is in North Carolina, but they got banks here in Georgia. These are franchises. Same thing, their home office is in Washington, D.C., but you a franchise, they gave you what? An EIN number, just like a corporation got. Franchise. All right, let's get back. I think that's a good enough overview. Let's keep going.
Every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And
Okay, brother, the term that you're looking for is recusal. You're asking the judge to recuse herself. Okay, and we're talking about freedom of speech here. Okay, for judicial bias, there's something called the Judicial Code of Conduct. And you'll be well, I think that is something that everybody should read. All right, the Judicial Code of Conduct. And she's sitting here trying to say, well, you know, every time you go off course, no, you have a right. You can challenge subject matter jurisdiction at any time, ma'am. At any time. Anytime I can challenge subject matter jurisdiction. And for you to have subject matter jurisdiction, you have to have a real party in interest with standing before the court. So I can challenge those elements. Who's the real party in interest? Do you have jurisdiction over the matter? Anytime you can challenge that. So she's wrong right here, and you need to put that on the record. You put that on record.
Okay, motion is denied. Anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor. Code of judicial conduct, judge, and I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal.
Interruptions. You can see a lot of judges use that technique. Interrupt you. I'm gonna show you another interruption. They know you're making a record, don't want you talking. Just keep on interrupting you. And try to use intimidation. I remember I had a judge in one time in federal court. You know, I'm coming in, I'm going through the whole court system, so everybody know me. And so I walk into the courtroom, you know, the judge, I didn't remove counsel, and counsel is standby counsel. So I'm telling, you know, so I walk into the courtroom, when I walk into the courtroom, I'm going to tell y'all this because you need to know, nobody in the courtroom but the prosecutor, me, 2 standby counsel sitting on either side of me, the clerk, the judge, and about 8 or 9 or 10 U.S. Marshals. And they were standing in every corner of the courtroom, 2 in this corner, 2 in the back, 2 on the sides, and 1 right next to me on each side. There's about 8 of them. So it was a huge courtroom. That's all that was in the courtroom. I was in custody. All right, so I come in chained up. They unchained me. All I came into the courtroom with was a affidavit of truth, Miller Act bonds, 273, 274, and 275, because we're dealing with federal, not state, not the 24, 25, and 25A. I had an international bill of exchange and a bond, I think. I only had like 4 pieces of paper I came in with. And so I was trying to file my Miller Act bonds into the case. Now I'm new. I don't understand everything that's going on. You're not supposed to file them on the record. But I was trying to file them on the record. And soon as I come into the courtroom, she started hollering at me. Sir, this is my courtroom. You're only going to be spoken to when, you're only going to talk when you're spoken to. And when I ask questions, do you understand what I'm saying? Yeah, I mean, just going off. I have not said one word. I'm sitting there. And I sit back and I just listen and I'm calm. Because when you see something like that, you're supposed to understand that that's blood in the water. They're trying to intimidate you. They're trying to knock you off your square. They're trying to rattle you. Don't let nothing rattle you. That's that last video. That was very good. Dude was very good at not letting anything rattle him. They said, we're going to put you on a felony. Nothing rattled him. He was even killed all the way through. And you got to remain calm. So I let her blast off. And when she got through talking, I just leaned back in my chair. I said, I'm sorry, but has the honorable judge made a judicial determination that I'm not going to be afforded my due process rights of freedom of speech in these proceedings? For the record, ma'am. See, all that telling me to shut up and sit down and all that, those are attempts to gain jurisdiction over you, because if you follow instructions, then you're an obedient serf. Like when you come into the courtroom, all rise. I'm in custody, I don't rise. And when I'm out of custody, I stand outside the courtroom, and then when the judge comes in, I'm looking through the door, and when he's all right, everybody walk, then I walk in afterwards. One time I didn't rise when a judge came in. He came in with a Bible in his hand. This is a federal magistrate. And they knew who I was. And when they all rise and I sat there looking, he walked in, he looked at me, and he looked at me like with terror in his eyes. I don't know what I was doing. Back then, I didn't know everything I was doing, but I could tell y'all some stories. It was just some surprising things that happened that I'm like, wow, it just let me know that a lot of this stuff is true. You know, I was just throwing mud up against the wall, you know, because I didn't know anything. But it was a whole bunch of stuff that was happening that was showing me like, oh, my God, I can't believe this shit is going on. Everything from putting undercovers in the cell with you. All that happens, you got to be ready for all of that. You know, next thing you know, you with some person in the cell, he talking about this, telling you things. Oh, you better be careful. They gon', you know, they'll drug you up. So then I had to go and start studying psychological evaluations. That's how you alleviate fear, with knowledge. Always don't succumb to fear. Fear is their biggest weapon. Threat, duress, and intimidation. Those are the tools of their trade to keep you obedient.
So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McQuarrie. Thank you, Mr. McQuarrie.
Yes, ma'am.
Your Honor,
Yes, sir.
they indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the chief judge.
He already
Well,
did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion.
Correct.
He requested the, thank you for affirmation.
See how she just confirmed what I said? The court doesn't require a written motion. You can make an oral motion. All right, just saying. Just be aware of that.
But I don't need it. He requested the recusal and I denied it. So ask them how to.
One more point. See how she keeps using the word requested? You have to listen to the words they use. That means you're asking for a benefit and a privilege from the court. And Ben, we know the detriment of benefits and this is a game all about rights versus benefits and privileges. This is if you want to be private and sovereign, you got to stand on rights. If you're not standing on rights, benefits, and privileges, you under their jurisdiction. So you got to listen to the terminology that they're saying. You demand rights. You don't. I'm not making no motion. I'm not making no request. This is demand, ma'am. And then you cite the support for the demand, and it needs to derive itself from the Constitution, because the Constitution is what restrains them. It doesn't deal with you, it deals with them. You don't have no constitutional rights. You have constitutionally protected rights, substantive rights, private rights under the republic, not in the democracy. In the democracy, you have civil rights. All right.
How do they want to proceed? I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is not?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your.
That's some bullshit. Everything is not going to be revealed. It's going to be revealed procedurally of what she wants revealed. See, when you're in the court, either they're conducting their business or you're conducting your business. And right now, it's just a struggle for domination. It's just like when a debt collector calls you. Sometimes I have this experience with debt collectors. If the debt collector calls you and they'll say, is this John Doe? You don't ever say yes. When I answer a phone and somebody calls me and the first thing they say is this, John Henry Doe, I don't ever say yes. Never. I don't care who it is. You don't call my phone and ask for me without identifying yourself first. I say, who's calling? And the conversation doesn't even go forward until they identify themselves. Especially if they come and say, we're on a recorded line. I'm on a recorded line, blah, blah, blah. Okay. Once they identify themselves, how can I help you? And usually if they identify themselves as a debt collector, the first thing out of my mouth is I don't do business over the phone. According to the Fair Debt Collection Practices Act under 15 U.S.C. 1692G, I'm requesting that you terminate calling me on the phone and contact me through written correspondence at all. Any additional contact after this is going to be $1,000 fine every time you contact me. Then after that, you get an address or an email where you can send it. They told you who their company is. Send them a certified letter under the Fair Debt Collection Practices Act supporting what you said. And every time they contact you, it's $1,000. Then download an app off of the App Store, a call recorder. They have some excellent call recorders, free apps, and record every conversation on the phone. It comes on soon as the call comes in. I can't tell you how many times that app has saved my behind recording phone calls. And also, just another tidbit of information. It is excellent to use the Better Business Bureau for administrative processes. See, the Better Business Bureau, you can write them a letter, then you can copy and paste that letter into the Better Business Bureau. They will send them a copy of it, and the Better Business Bureau will tell them to respond to them. So the Better Business Bureau is acting as a notary, as an in-between. They are excellent resource to conduct an administrative process with the Better Business Bureau. And it's on the and they're gonna answer them. They're gonna answer them. They got to. In my opinion, a Better Business Bureau is more powerful than a notary. It's more powerful than the notary to me. FYI.
Has your current contact information so that the Chief Judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McCrary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr.
this
McCrary,
is
I don't take
man.
things personally. Ms. McCrary, let me say something to you. So since we talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
Correct.
maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a Black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old Black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCrary, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Oh, yeah.
Okay, I hope y'all are enjoying today's class. Because this is an example of how a judge, how they can run. I don't want to use the term railroading, but it does. You can get railroaded like this. This is a technique that a lot of times can be used in railroading someone, not allowing you to speak, running over you. Even though she was correct in a lot of things that she was saying, because he was not making good legal argument, and he wasn't addressing the court in the correct way. Objection, Your Honor. Sustained or overruled. Don't make requests. Make demands. If we're talking about rights. You say, for the record. For the record, Your Honor, is this a civil or criminal action? For the record, Your Honor, am I to understand? For the record, Your Honor, have you made a judicial determination that? Professionalism. All right, let's go to another one. Y'all want to look at another one? Let's see if I can pull up another one. Because that was a short one, but that was good. You know, it was good. I think it was a good example. I'm gonna pull up an oldie but goodie. I'm gonna pull up an oldie but goodie that I wanted to talk about. Oldie but goodie. Where was this thing at? Now, these gentlemen, I actually interviewed him on my show some years ago. Because what I liked about this is another Moors in Court. This is a classic, and it's a classic, and the reason it's a classic, what I liked about these gentlemen,
as a constitutionally.
What I liked about these gentlemen is their spirit. And I think they exemplify the spirit of the Moors, and when they go into court with the Nationality Defense, they were not successful. And I understand why after watching this, and I'm gonna show you why. They learned from their mistakes. But I really admired both of these brothers for how they came into court and the things that they attempted to do and trying to assert their status before the court. It was really interesting, and it's just every time I see them, I'm like, yeah, you know what I'm saying. They have the right spirit. They didn't have the right knowledge, but they had the right spirit. And that's what I like about this right here. So let's look at this real quick. Let's go into this. Let's see what we got.
And do not point to
Yes,
me.
you have a constitutional oath to uphold the Constitution, ma'am.
You misunderstand the procedure. I will attempt to explain it to you.
Objection.
The documents that you want are not documents that are in the court's file at this point in time.
Objection,
I don't know
ma'am.
if they would ever be in the court's file at this point in time.
That's not my problem, ma'am.
Absolutely, it's your problem.
That's
your
not my
position
problem.
is that you want them from the prosecutor, and you have requested them from the prosecutor.
That's right.
And the prosecutor has failed to give them to you.
That's right.
You can make the appropriate application to the court, and you can say to the court, I've asked for them, I'm entitled to them, I haven't gotten them, order them to give it to me.
I've already filed
received
a
no
notarized affidavit of fact in reference to return of property weeks ago. A notarized affidavit. So if you're telling me you don't have to acknowledge affidavits, all right, that's what your statement is. However, bottom line is this court has failed to prove jurisdiction and has avoided the issue of jurisdiction at all costs. And nobody in here has the status. All right? Nobody has proven status, and nobody in here has the authority to proceed. Now, the last hearing we discussed.
Entitled to them, I haven't gotten them, order them to give it to me.
I've already filed
received
a
no
notarized affidavit of fact in reference to return of property weeks ago. A notarized affidavit. So if you're telling me you don't have to acknowledge affidavits, all right, that's what your statement is. However, bottom line is this court has failed to prove jurisdiction and has avoided the issue of jurisdiction at all costs. And nobody in here has the status. All right? Nobody has proven status, and nobody in here has the authority to proceed. Now, the last hearing we discussed, you stated that
Could you please stop yelling at me?
this matter, you stated, ma'am, for the record, you stated that this matter was relative to jurisdiction, not Mr. Kiesler's position here and not anything else. You stated that you were giving the prosecution a chance to prove jurisdiction, and he's not even the assigned prosecutor to the case, but obviously he's remaining silent, and he has nothing to state. So I move that this case be dismissed.
When there is an appropriate application before this court,
Okay, what I want you to pay attention to, he's going to be making objections. She's never going to say sustained, overruled. He just made a motion. It didn't get answered. Okay, this right here is going on the record. And when the appellate court sees it, they're going to interpret it and they're going to take silent judicial notice that you acquiesced. And you're not going, you say, well, I did a motion, I moved the court to dismiss. She just went and started talking about something else. He's going to say objection 1,000 times. She's not going to say sustained or overruled not one time. That's called an equivocal ruling. They're trying to avoid committing on the record. These are techniques that they utilize against you while you lose. I saw a gentleman in the chat. I saw you, Stefan Lewis Sale. It says, you would like a Moorish American member with courtroom experience. I'm here. Remember, I'm the gentleman that received the Michigan Rules of Court book from my court-appointed attorney, now judge. Okay. I mean, that's cool. I'll do a call-in show and let you call in and you can talk. That's fine with me. I don't have any. Matter of fact, I think what I'm going to get back to doing is I'm setting up a podcast studio where I can invite people in and start interviewing people again. Because, I used to interview a lot of people on my blog talk. That's how I started out. A lot of people didn't know that my original platform was allowing all the other people who have not, I'm not the only person with knowledge in this. There's some other very extremely intelligent people that know this information. Don't sleep. I'm just popular because y'all like listening to me, but there's some other dudes who can get down. And, and I was fortunate enough to meet those individuals and invite them onto my platform, and then let my listening audience be able to benefit from the knowledge that they have. So I'm more than happy to do that again. Trust me. All right. I'm just doing this right now. It's like I said, I'm showing out techniques that they use. It's not an attack on the Moors. It's showing techniques that they use to circumvent things. That's what I'm doing right now. It's not. And then, and then some of the errors that people do make as well. Some of the errors that they make. Because you got to understand, they go by procedure. They're utilizing procedures to be almost 98% of the stuff that I read where people lose is because it's some sort of procedural defect or procedural error on the defendant's part. It's procedure, even when it goes to the appellate. A lot of people appeal things. They don't understand what's being reviewed on the appellate level is procedures. Because now you're getting into constitutional questions, and the procedures are there to ensure that the Constitution is that they operating within their ambit of their delegated authority within those constitutional limitations. So if they do everything correct procedurally, you're going to lose. And the same thing with a police officer. If he shoots somebody dead down in the street, what do they say? They do an internal investigation. If he does everything according to procedure, they put him on administrative leave. He keeps getting paid, and you're going to bitch and complain about it. But you have to understand that they are employees. And when an employee follows procedure, that means he's doing what his boss tells him to do. So how are you going to sue someone who's doing what their boss told them to do? That is why when you sue a public official, you're suing the state. You only have grounds for filing liens and doing all things like that if they act outside the ambit of their delegated authority. You have to be able to demonstrate that. It don't have nothing to do with the way you goddamn feel. Fuck your feelings. I give a fuck how you feel about something. I'm mad. But get your feelings out of this, nigga. This is business.
Address the issue of discovery violations, jurisdiction, or anything else, the court will act. Filing a notarized or not notarized affidavit is not an appropriate way to bring a matter before the attention of the court. What you must file is a notice of motion that sets forth the relief that you want, and it needs to be supported with a certification, an affidavit, whatever it is.
Can you repeat that, ma'am?
Notice of motion.
That's what the same thing you were telling the man on the last video I did. If you file something, a motion, and you want to hear have oral arguments about it, then you need to file this notice of motion that she's referring to, and then we'll schedule a hearing date on that. Now, it's procedurally, that's what she's doing. However, you have a right to challenge subject matter jurisdiction at any time. Why do I have to file a motion? Okay, you don't have jurisdiction. Okay, you don't have jurisdiction to tell me to do shit. Not file. I don't even want to have to come to court if you don't have jurisdiction. This is the matter we're talking about. But once again, you can fall within that jurisdictional element very easily. Something as easy as answering a question. When you answer a judge's question, you have granted jurisdiction. You know why? Because you made an appearance. Okay? A judge can't hear or see you till you make an appearance. They can't hear or see you until you've made an appearance. An appearance, let's take time to look at this word appearance. Because this is a very important word. Let's take some time to look at this word appearance. Appearance. Let's go back over to SBC University real quick. And on SBC University, we got our dictionaries right there. We got a whole dictionary library. Going to go to our Faithful Black's Law. Going to go, I always use the 8th. It's not nothing particular about the 8th. It's just, when I was learning all this, it's a dictionary I'm very familiar with how to get around on. It's not that it's a better dictionary or anything like that. All right. And we're going to go Control F and put in appearance. All right. All right, appearance. All right, let's look at this very closely. Appearance. Procedure. Procedure. A coming into court as a party or interested person, like a third-party intervener, or as a lawyer on behalf of a party or interested person, especially a defendant's act of taking part in a lawsuit, whether by formally participating in it or by answer, demur, or motion, or by taking post-judgment steps in the lawsuit in either the trial court or an appellate court. All right, let's look at the expert commentary, because we got to get a full understanding of this. All right, you see all the ways you can make an appearance? Attorneys generally put in what is called a notice of appearance. If you look at the docket sheet, you'll see when you hire an attorney, they have somewhere where they put a notice of appearance. They don't necessarily have to do that because filing a motion constitutes an appearance. All right, so right here it says the English courts did not until modern times claim jurisdiction over the person of the defendant merely by service of summons upon him. It was deemed, careful of this word deemed. Anytime you see the word deems, it means they're creating a fiction. It means an assumption. There's some sort of assumption, even though it may be untrue, but it's going to be made true, especially for judicial reasoning. So it was deemed necessary to resort to further process by attachment of his property and arrest of his person to compel appearance. That is admiralty. That is exactly what they do in admiralty. A writ of attachment is when they seize your property, okay, and then they compel your appearance. That's what they do. They arrest you, which is not mere presence in court. What is this? Appearance. All right, let's read this again. It was deemed necessary to resort to further process by attachment of his property and arrest of his person to compel appearance in quotes. Now, we put it in quotes, they're going to tell you what appearance is, which is not mere presence in court. So just by you being in court, that is not an appearance. But some act by which a person who is sued submits himself to the authority and jurisdiction of the court. Any steps in the action, such as giving bail upon arrest, operated as an appearance of submission. You see how much you can find out just by reading the goddamn definition? I can't tell you how just frustrating my position is to be doing this for about 10 years. And all 10 years I've been telling people to look up definition of words and motherfuckers just don't ever do it. If you're new to this, you should spend your first 6 weeks with nothing else but a dictionary in your hand, looking up and writing down words. The motherfucking dictionary is amazingly interesting. And you start out with all the words you hear all the time. Look up charge. Look up trust. Look up appearance. Look up bond. Look up bail. You start with those words. Look up civil. Look up, look up administrator. Look up Article 1 court. Look up Article 3 court. That's all I did. And you know what happens? When you start doing that, the words lead you to other words. And then you see how all the words are interconnected. And the next thing you know, the dictionary, once you immerse yourself in it, it takes you on a trip. Then you find yourself studying feudal law. Like, damn, how the hell I end over here in the feudal law? Studying feudal law just by looking at these damn words. How you gonna play this game, which is a word game, and you don't motherfucking like words? How you gonna win, and the person you going up against has a vocabulary of 10,000 words and you got a vocabulary of 500?
This is exactly what I told Cheyenne Matoda Kushner L.
For the record, man, which rule or authority, courtroom rule, statute are you using?
It's in the court rules. I do not
address that
recall.
matter?
It is in the court rules. I do not recall, and I'm not going to look up for you the exact court rule, but the court rules set out the procedure that you must follow.
Objection, ma'am. I'm not a party to society. I'm not subject to your courtroom rules, and you have not proven jurisdiction.
And
Now,
I
if you
will
can't
never
prove
address the
jurisdiction,
issue of jurisdiction
Then you-
until and unless the appropriate application is made before the court, because filing either an affidavit that's notarized or an affidavit that's not notarized does not bring it before the attention of this court.
Objection. There is no discretion to ignore the lack of jurisdiction. Joyce versus United States. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction in here is void ab initio, and that is application of Y300 P.132 versus caveat. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Melo versus United States 505 F2D. When jurisdiction is challenged, the party invoking jurisdiction has the burden of establishing Basso versus U.S. Power Light Company. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity and
Is somebody in the chat telling me not to use a symbol? You put that out there in the public, I'll damn well use whatever I want to. If you don't want it on something, don't put it out in the public. I'm reviewing a court case. I'm not a part of the Moorish Science Temple of America, and I'm not under any obligation to follow anything. You put this in the I pull this all Google Images. Please don't set me off, man. I'm telling you right now, don't set me off. You don't want to go to war with me. You do not want to go to war with me. You think you do. Maybe your your pride and your arrogance may think that you want to. I've been doing this 20 years. I got a motherfucking war chest of information. War chest. It'll be like I'm America, Russia, and China combined, and you are some third world country. That wasn't even necessary. I'm sitting here trying to help you and your society. What issue do you got with me? Are you a sheikh? Are you a Sheikh? What temple do you belong to? This guy, MST of America Mission 28 Sheikh Talik El. What temple you belong to? Don't get me started with that, man. I ain't got time for that right now. I got a job to do. You should be doing this job. Mm-hmm.
Like courts of law do not attain jurisdiction by service of process, nor even arrest and compelled appearance. I'm here by way of threat, duress, coercion. I'm going to make that clear for the record every time I have to appear here, if I have to appear here. The only reason I'm appearing here is by way of your threat, duress, coercion, or your company's threat, duress, coercion.
You can
Once
read
jurisdiction
me,
is challenged.
let me interrupt you, please. You can
Okay.
read me this until the cows come home. You can read it ad nauseum and ad infinitum. It doesn't change the fact that until the issue is brought appropriately before this court, no ruling with regard to jurisdiction is ever going to be made. Now, let me ask you this question, though. In the other matter, first of all, let me backtrack a little bit. Let me get the correct number out here because we now have two numbers. In the case with indictment number 08-04-0441, which is the one in which Cheyenne M. Cushamirel is also involved, I have severed those matters, so they will be on completely separate tracks. But he told me that he had filed a notice of removal to the federal court, and my question to you is, have you filed a notice of removal to federal court with regard to any of these matters?
Yes, ma'am. Notice of removal
All
has
of
been
them?
filed
All of them?
regarding all matters.
The three matters?
Yes, the three
Okay.
matters that you.
May I ask you, please, would
currently
you tell me,
referenced.
when did you file this?
They were filed last night, FedEx.
To
By
the
way of
federal
FedEx,
court?
to the federal court.
All right.
Yes.
Now, as I am sure you are aware, if the court accepts them, then we will simply transfer them to the federal court. We won't deal with them anymore.
Okay, well, I'm still sure you're aware of the matter that you've not proven jurisdiction in either of the hearings and that you've avoided addressing the issue of jurisdiction.
And I will continue to not address the issue of jurisdiction until the appropriate motion is filed with the court and the court has the ability to address it and make a determination with regard to it.
And Judge, if I could just for a minute, that's the issue at hand. As currently stands, we are representing.
Objection. You're not representing me.
Judge. Therefore, it would be our responsibility to file that motion. Given the fact that he will not cooperate with our office, it's impossible for us to do that.
Objection.
We really need to
Well,
reach the issue.
I want to get
Objection.
back to what I do want to get back to what Amir KCL said. Now, we addressed the issue to some extent with regard to the indictments. I have here for you, and the record will reflect, that I am giving you a copy of the indictment that has 08-07-0727 and also 08-04-0441.
Objection. Just for the record, the Office of Public Defense is not representing me. You don't have any power of attorney for me, and I'm not part of your society, so you cannot represent me, and we do not share nationalities. Okay, now, for the record,
Mr.
I need the
Kramer.
nationality of every agent in here, and I need the name and the information because I'm suing everybody.
Mr. Kramer.
Okay, and that was that is very appropriate to always get people's name on the record. You know, I don't know if I would have issued a threat like that, but you definitely want to get the name. And to the more in the chat, real quick, this guy over here, this guy right here, his name is Law Talk with Mike, which I think you should look up his nationality. The reason that I'm doing these Moorish videos is because he's over there making a mockery out of you and your entire organization. But you over here mad at me because I got a thumbnail. He over there putting on fezzes and all kind of things, making a complete mockery of your organization. And that is what made me want to come over here and start doing these reviews so I can have something to counterbalance that. And you mad at me because I put up a thumbnail. And this man over here, he's putting on fezzes and all kind of things, telling the whole world what complete idiots all of you are. Making money doing it. I'm just saying.
Everybody. So I need everybody's name and your position, starting with you, sir.
Who is calling out from the audience?
I was, ma'am.
No, you were not. Who was, no, do not hand anything over. Nothing. In the audience, please do not call out while court is in session or the officer will ask you to leave.
Making sure everything's still going through. I had a technical difficulty real quick, but I'm back. Make sure everything's going good. And we're going to continue. There's a part 2 to this real quick. I apologize about that. Apologize, but I don't know what happened, just technical difficulties, but I'm back. All right, so here, let's get to the second part of this video.
These are now completely discombobulated. They're not stable to, well.
But the one wasn't stable enough. The one was.
No, I don't have, look, you can't even read this. Is that what I gave you?
I think so, yes. I give you back the original. Do you have the copies? I gave them to her.
Okay. I need your name and position, sir. I need your name and position, sir.
No one is going to give you any information.
Ma'am, are you stating that you are not obligated to provide me with your identity and status?
You know my name.
your employees or your co-workers are not obligated to provide me with their identity, status, and company position now? Stating that you are not obligated to.
One of the most powerful things that you can ask a public official is for their name. The purpose of asking for the name is so that you can have something to put in a commercial registry, that you have something to file a claim against. Okay, and it has to be. So what he's doing is right now, she don't want to give her name. And you're going to find a lot of officers, they cover up their badge number, their name, flip their badges over, because that's one of the most powerful things that you can ask someone, because all public officials have an oath to uphold the Constitution for the United States of America. They are bonded. They should have a bond on file with risk management with the appropriate municipal jurisdiction that they operate within. Okay, these are things that asking the name while you're doing that. Yeah, I remember one time I had a judge try to get me with a contempt because he told me to sit down, and I told him who he's talking to, and he wanted me to apologize. He said, look, he said, either you're going to do 10 days in jail or you're going to apologize. And he was like, now I want you to say number one and number two. Either number one, you apologize. Number two, you're going to do 10 days in jail. You don't want to apologize. I want you to say nothing else. And the way he said it to me, because, you know, they doing that. They're trying to assert dominance over you because we are the sovereigns. And you got to understand that this socialist, Marxist, communist has infiltrated your government on all levels, this thinking and everything, man. Let me tell you, you just don't understand how pervasive that it is. And they don't like that word sovereignty because that goes directly against their plans for a new world order. You got to understand, if you're not with the new world order, you're an enemy. All right. So how they talk to you, everything that you see is trying to assert dominance over you. So when he said that to me, all I said was, I'm sorry, sir, what was your name again? And it caught him off guard. He got real nervous and scared. You know, he's like, I don't want you to say nothing. I said, I'm sorry, sir, what was your name again? I said, well, you know, just give me number one. And I apologized and got it. And it's a really interesting story because there's no need to go to jail at sometimes, you know, for something like that. If you can just walk away, just fucking walk away. Because we're talking about ego right now. That whole situation between me and him was all an ego thing. And I'm not going to spend time in jail over my ego, you know. And but still, I threw that jab at him just to let him know. If you want to take it there, you sure you want to lock me up for 10 days? Because it can get ugly. Just saying. While we're at it, I'm going to interrupt this real quick, and I'm going to show you an example from a movie of forming an objection. And it's from the movie True Grit, and I love this movie. And what went on, this is a courtroom scene, and I think it is a very good illustration of what goes on in court and how you do objections and when an attorney is trying to testify and how to handle that. So let's take a real quick look at that real quick.
Hearsay.
By declaration, Your Honor.
Objection's overruled. Proceed, Mr. Coburn.
All them two Wharton boys, that'd be Otis and CC, throwed down on him. I asked him where his money was, and when he wouldn't tell them, they lit pine knots, held him to his feet. He told them the money was in a fruit jar under a gray rock at the corner of a smokehouse.
And then?
Oh, he died on us, passed away in considerable pain.
What'd you do then?
Well, me and Marshal Potter went out to the smokehouse, and that rock had been moved, and the jar with the money in it was gone.
Objection. Speculative.
Sustained.
You found a flat gray rock in the corner of the smokehouse with a hollowed-out space beneath it.
If the prosecutor's going to give evidence, I suggest he be sworn.
Mr. Cockburn, what did you find, if anything, in the corner?
Did y'all catch that right there? How he caught that prosecutor testifying? And that happens a lot. In particular, especially in foreclosure cases, when they haven't brought any witnesses in. They got all hearsay evidence because they got copies of deeds and everything. They do not have firsthand knowledge of anything. Attorneys don't have firsthand knowledge of anything. They can't testify. They come in there without any witnesses or anything like that, and they start talking on the record. You should be objecting to everything they say. Objection, Your Honor, hearsay. We need someone who can come in and testify under penalty of perjury to the contents, to the veracity and validity of the contents of the documents the counsel is attempting to proffer in evidence. Sustained to overrule. If they say, well, I just think I'm going to let it in, I take exception to the honorable judge's refusal to rule on my objection. Sir, would you please enter sustained or overruled into the record so I can preserve the error? I'm making a record here for a pet. There's undoubtedly there's going to be a need for an appeal. So I need you to rule on my objection. You got to catch all of this. I don't know who this fool is that keep flashing True Grit. It's just some dumbass motherfuckers on the internet. Shit, they just make dumb videos. Keep on flashing this True Grit on here.
Know that smokehouse?
Found a flat gray rock with a hollowed out space under it, nothing there.
And then what did
No
you...
jar, nothing.
Yeah, what did you do then?
Well, rode up to the Whartons there, and there were the North Fork strikes of Canadian.
What did you find?
Answered the Canadian. I had my glass, spotted them two boys and their old daddy Aaron down the creek bank with some hogs. They'd killed a shoat, had a fire built under a washpot for scalding water.
What'd you do?
Now, as we was U.S. Marshals, I hollered out to Aaron. We needed to talk to his two boys. He raised an axe, commenced to cussing us and blackguarding this court.
What did you do then?
Oh, backed away from the axe, trying to talk some sense into him. While this was going on, CC, he edges over to the washpot there behind the steam and picks up a shotgun.
I think that was it. I think that was it right there. I'm going to go back to the court case, but I was just using that to illustrate that's a good movie to watch. It's a very good movie in the first place because the little girl's like 13 or 14 years old, and it shows how back in history, how the children were taught by when they were homeschooled. One of the things they were schooled in was how to manage an estate, because her father got killed and she was able to handle the affairs of the estate of her father and how they were very familiar with law. That's an excellent movie. She understood what malum in se versus malum prohibitum was. And a lot of other words. I was just tripping. I'm like, man, this chick right here, wow. I was really very impressed with her knowledge of the law. She's like 14 years old. And that's how it should be with our children. There is no reason why law should be taught as early as 3rd, 4th, 5th grade, things like that. I don't understand why it's not. You're expecting citizens to be educated about their rights while in public, because public school is not designed for that. Public school is designed to create slaves. Public school is designed to make taxpayers and consumers. If you don't want to be in those categories, you got to get your education from somewhere else. Let's get back real quick.
Any decisions for me, and neither do you, and neither does Mr. Kiesler, and neither does the Office of Public.
That Judge Smith has required Mr. Kiesler to represent you.
Objection. I've addressed this matter with Judge Smith. Judge Smith does not have jurisdiction and could not prove jurisdiction. Therefore, Judge Smith does not have the authority to make any decisions for me, and neither do you, and neither does Mr. Kiesler, and neither does the Office of Public Defense. For the record. Now, as I stated, you just told me that you did not hear my question. My question was, I need the information for the people here who are attempting to force business on me. I want his name and position, I want her name and position, and I want his name and position, and I want your nationality.
Not to point at me, and I am now going to ask you not to point at anyone else in the courtroom. It is very impolite.
No problem, ma'am. Now I'm asking you to answer my question.
You know my name. That is all you need to know.
Objection, Your Honor. That's not all I need to know. Now, she can acquiesce to that if she wants, but I need to know your name, all right? Because when you get the transcript, all in the transcript is going to say is the court. The reason for that is because they operate under the cloak of immunity, okay? Now, they are immune as long as they operate within the ambit of their delegated authority, which she's doing. She hasn't come outside that. Right now, she's just whooping his ass procedurally. That's what's going. He doesn't know that he's granted jurisdiction by answering questions. Even the cautioning is a grant of jurisdiction. Like, hey, look, don't point your finger at me. Things like that. You know, all these things are granting jurisdiction. She's taking silent judicial notice of that fact, and she also understands that it's going to appear on the record. So she doesn't have to say it. The appellate court judges are going to see it. It's all on the record. The record, she's making a record. You got to learn how to make a record too. So I didn't see anything that she did wrong. And it's a very good, matter of fact, I like to use this as a teaching tool because she was very, very good at obfuscation and avoiding things and understanding that she got somebody in front of her who doesn't understand procedure and doesn't know how to make a record. The only thing where he started kind of tightening screws on her is when he asked her for a name. You can see her disposition change a little bit. You know my name. She don't want to give a name because a name goes in the commercial registry. A claim can be filed against. Checking their nationality is very important. Nationality of everybody we're dealing with right now is vitally important, especially in light of what's going on in Israel and Palestine. Because you're going to be shocked. You're going to be shocked. This is why I want to read this Mein Kampf, because Hitler did the same exact thing I did. At first, Hitler wasn't against Jews. He went to Vienna. He liked art. He was an artist. That's all he wanted to do was be a painter. That's all Hitler wanted to do. And he went to Vienna to an art school to be an artist. And that's when he first came into this thing about anti-Semitism and first introduction into Jewish people. And he just saw him around the city. And then he was looking at the newspapers. And at first, he didn't understand that the newspapers were all owned by Jews. And he noticed that everything in the newspapers was against the German people and how they had the German people at each other's necks. The same thing that's going on in the United States today. And I mean, the same playbook. And only an astute person who's observant would be able to discern it. And he also talked about how at first he thought everybody was being, unfair with the Jews and things like that. He was on like, what is this? This is not professional. These are not the thing. He didn't understand what was going on. But gradually, as he began to understand this democracy, because they are the ones that push democracy. The civil rights and all of that, and he began to understand what it truly was. Man, that's an interesting book to read, and you can see like, damn, this is the same thing that's going on today. But I'm kind of nervous of reading it because I'm going to get labeled anti-Semitic just for reading a book that's published. You probably can't even read the book on YouTube, you know what I'm saying? But it's something that they got a PDF of. It's very, very interesting because you have to analyze it. Because you can see that he did the exact same thing I did. Next thing he know, he started checking the nationality of everybody. Same thing I did. I can show you right now, 70% of your people in your government are Jewish. Probably 70%. You ain't even paying attention. The reason you don't know that, because you just call everything white and black. And white people don't consider themselves Jews, and Jews don't consider themselves to be white. But your ignorant ass, you don't make any distinction between the two. You're going to call them what you want to call them. And that is why you will always be in an inferior position because of your arrogance and hubris, thinking you know everything. You're asking people to check our nationality, but you're not checking the nationalities of the people who are your adversary. I find that interesting. You dealing with this whole game is socialism versus the republic. They're trying to tear down the Republican form of government. They're trying to eliminate private property rights. All these young people coming out of college that's attacking capitalism, they don't even understand what they're doing. They don't even understand. They've been brainwashed in these liberal schools into thinking that capitalism is evil, Okay. And the only alternative to that is socialism. And socialism is when the government owns everything and tries to put everybody on an equal footing. If you notice, these people who adhere to this political ideology, at the same time, they don't believe in a God. They don't believe in a God. They're atheistic. Right? Ain't no God. Ain't no Jesus. Religion is trash. There's no God. Now, what is interesting is the professors, the Jewish professors, and the people who are proselytizing and indoctrinating them with this ideology, they subscribe to a religion. They subscribe to the Torah. So what seems to be going on is the creation of a heathen, because in Leviticus 24:45, heathens can be made into slaves, which is what they're doing, made a bondservant. So what I see what's going on has been a progressive plan to change the goyim on the record into heathens through agreement. He who can be deceived, let him. That's a Roman maxim. He who can be deceived, let him. So under Roman civil law, if you can be deceived, that's on you. And I hate to bring this up, but it's something that needs to be talked about because it's in your courts. It's everywhere. If the attack on the sovereignty is an attack on the republic, it's an attack on private property, it's an attack against people who are not towing the line for the New World Order. They want a hive mindset. They want everybody thinking the same. They don't want no independent thought or anything like that. You coming into the courtroom talking about you are sovereign, that's a direct threat to the New World Order. That's why it's important that you study history. It is important that you understand law. It is important that you understand your state and federal constitutions, because this is what restrains them. And they're doing anything to circumvent that. And they found a loophole to circumvent that, this plenary power doctrine under Article 1, Section 8, Clause 17, under this territorial jurisdiction. That's what they operate under, not in the Republic, not under common law. They are operating under the Constitution, though, because the Constitution is the grant of territorial jurisdiction. So don't say they're operating outside of the Constitution. No, they're not. No, they're not.
I don't know your name, man.
Judge Laban, that is my name.
Your nationality?
You have no need to know my nationality.
Yes, I do. You are attempting to force business upon me. I need to know your nationality. For the record. And your status. For the record. And anybody else that's working with you.
Your questions are unintelligible to me.
They're unintelligible? Do you not understand what nationality means, ma'am? Do I need to pull out the dictionary? Which dictionary are you comfortable with using, ma'am? For the record.
All right, the record should reflect that I am going to give to Noble Amir Kusamir L.
You said you just ignored him and just moved on? That's acquiescence if you don't say anything. Let the record show that I have requested of this court that they reveal to me the status and nationality of its participants, and this judge has refused to do so and has remained silent on that particular matter. Pursuant to the Sixth Amendment, and you got to be able to identify what law that you're asking that question under, pursuant to the Sixth Amendment. For instance, when you ask them the nature and cause of an action, you come back and say, let the record reflect that I've demanded of this court, under the authority of the Sixth Amendment for the Constitution of the United States of America, for this court to reveal to me the true nature and cause of this action, and this court has refused to do so and is now seeking to proceed against me under a secret jurisdiction that is known only to the judge and the prosecutor, for the record. You put shit like that on the record. You gotta make your point known. You know what I'm saying? You gotta drill it home if you want to get them to dismiss something. You gotta turn screws on them. Gotta know how to turn the screws. And everything is about how to ask questions and how to deal with interruptions, obfuscation, ignoring your questions, using procedural tactics against you. All these are the tools. And then when you lose, they'll come back and say, yeah, see, the sovereign citizen shit is some stupid shit. But really, what only happened in the court is that you just got whooped procedurally. The substance of what you were talking about never gets addressed. But to the layman watching, all you look like is a bumbling idiot. And I'm going to take down the thumbnail. I'm going to honor y'all temple. I'm going to take it down. But still, I don't like that when y'all come, y'all say something to me, but these people all on the internet, they ain't in your society at all. They making a complete mockery of you, putting your symbols up and everything. I just think it's just interesting. You attack me, but you don't say nothing to them. You don't say none of these, the white man, and nothing like that. I just think it's interesting. All right, let's continue.
I'm sorry, Noble Amir KCL, a copy of Indictment 08-07-0727 and Indictment 08-04-0441.
Objection, ma'am. Could you state for the record who those indictments are addressed to?
Well,
stating who you were giving to. Objection. Wait, no. Hand that back to her.
I am handing the papers.
She needs to state for the record.
I am handing the papers to Noble Amir KCL.
I need to know who's on it, ma'am.
It doesn't matter who's on it.
Yes, it does.
I'm giving you copies of papers.
I need to know who's addressed to.
Read it.
If it's not addressed to me,
read it.
You've not read my notarized affidavits.
Read it.
You've not read my notarized affidavits.
Well, this is what I'm going to do. I'm going to give this matter another date. Mr. Kiesler, you can make whatever application you want. Noble Amir KCL, you can make whatever application you want. Hopefully, in the meantime, we will hear from the federal court with regard to the removal application.
I'm going to just state for the record that your application to do any further proceedings are denied because you have not proven jurisdiction, neither has the prosecution who was here and present. Prosecution, would you state your proof of claim for the record?
Your Honor, would any motion by our office be heard on the next date, or would you set a separate hearing?
No, it will be heard on the next date.
Thank you.
For the record, your application to proceed to set any hearing.
Okay, let me talk about the indictment. And I like what he did right there by not accepting the paperwork. Usually, though, like if you're in custody, see, this is another thing you have to understand. You're going to operate differently when you're in custody as opposed to when you're free. They two different dynamics that are going on. When you're in custody, it's a whole nother ball game than when you coming in off the street going into court. So don't think they kind of operate the same way. When they give you the indictment, usually what you can do is when they hand it to you, because they don't never read it, look on the front and back and hand it back to them and say, I see no charges. I request that the Honorable Judge direct the prosecutor to read the charges into the record. See, we have to establish liability. Who is the person bringing the claim? Okay, that person is the one that is going to be liable in case you win. Somebody got to be liable. First of all, you done brought me in this courtroom and then wasted my time. So I had to come in here and spend hour, 2 hours in here talking about this stupidity, okay? Or you lock me up or something like that. So there's some sort of injury we need to discuss, and I need to know who the liable party is. So who is bringing the claim? So we need you to read those charges into the record, ma'am. You don't need to see it. Just look at it and say, I don't see any charges. I request the Honorable Judge direct the prosecutor to read the charges into the record. What you're doing is you're getting on the record for him to establish the liable party, liability, who's bringing the claim. Because they operate almost 100%. They are skillful in their documentation in court. All this is ways of attempting liability. Her not giving her name, ignoring things. All this is to escape liability, to remain under the cloak of immunity. Learn the game. You know, when you play chess, I'm a pretty good chess player. I'm not going to say I'm the best, you know, because I can go down to Atlanta in the park with some of the homeless people. They can whoop my ass. I'm not good on that damn timer. I get my ass whooped on that timer. I'm not good at time chess. I'll whoop you on regular chess. But that damn clock, I'm not, I need to practice it. I just never got into it like that. But, you know, when you first start learning chess, you know, you learn moves and everything. You learn how to, you learn defenses, you learn openings. Then you learn how to think 3 or 4 moves ahead. You learn how to sacrifice pieces to gain a position and leverage and things like that. You understand the importance of pieces. You know, for instance, you could have just a king and a queen, but hell, I might have 2 rooks, a bishop, and a knight, and I'll whoop your ass. You know what I'm saying, or something like that. Or maybe with just a rook, a bishop, and a knight. You know, if you really know how to play. You know what I'm saying? You can fend off an attack of a queen. You know, so the same thing is with this right here. You playing chess. This is like chess going into court. It's a verbal joust. And your pieces are your understanding of certain principles. All law rests on principles of law. So one of the things is you should be studying are principles of law. The Supreme Court justices, they make their opinions based off principles of law. And the first principles you should be studying are the 7 principles of the Constitution. And then get into the back of and I'll show you what I'm talking about. All right, so this is an appendix right here in Black's Law Dictionary. And they're in the back of all the law dictionary. You got a Black's Law 8th, 9th. Let me see right here. All right, these things right here, these maxims, you want to spend time just reading these. You know, the seller beware. The cause ceasing, the effect ceases. The cause ceases, this cause and effect. One of the principles under the Kabbalion I'm always talking about. The cause ceases, the effect ceases. When the reason of the law ceases, the law itself also ceases. All this is cause and effect. A deed of a thing not in being is not valid. Let's get down here somewhere. The reason of contrary things is contrary. There's no disputing against one who denies first principles. And the first principles, I forgot what they were in law. The first principles, they discussed that in Chisholm versus Georgia, first principles. I forgot, I can't think of it off the top of my head. The law never allows anything contrary to truth, right here. These are principles. They got the Latin right here. The express agreement of the parties overrides the law. Right there, contract makes the law. That's another way of saying it. The express agreement of the parties overrides the law. This is the basis, the principle that your administrative process rides on. See, these are the things you want to understand first before you even start discussing statutes, codes, common law. Now, this is what the common law is. It's based off principles. The common law is unwritten law. It's a set of principles that do not come into manifestation until there has been a dispute and facts have appeared on the record where those principles can be applied to. That's what it's called, your case law. Judge Bouvier gave the best definition of common law. I'll do it on another case, another time, because I got the document where he gives, I don't know, can I, let me see if I can get it right now. Hold on, I might can get it right now. Let me see, because we're in class, so y'all need to understand, because I hear people talk about common law all the time. What is the common law? What is the common law? The common law. You know, the common law. Everybody wants to talk about the common law. Also, I got courses on SBC University too. Let me see if I got. Oh, look, I guess an error right here. I gotta go and repair this right here. I didn't know that was happening on my website. I'm gonna go and repair that when I get off. Trying to see if I can find this. This right here are all the courses on SBC University. You see we have Business Trust Manual right here. And let me see, did I put this is course content, step-by-step procedures in setting up your pure equity trust table, installation of private equity trust, setting up your bookkeeping. That right there is one. That's not the one I was looking for, though. Using your exemption, commercial liens, exemption, presentments, credit mastery. Is it not up? I'm going to have to go back and look at that. Have a look at that. Got Top Secret Banker's Manual here. These are all courses that you can take on here, and you get a grade and things of that nature. Really, really interesting. All right. I was looking for this document, man. I can't, I'm looking for this document. And I wanted to show it to you, but I don't know where, I haven't looked at it in a while. I don't know where I put it on here. I know I got it. I have to come back to it. I'll come back to it. But what it was is Judge Bouvier's, it's in my trust course. You know, I got to find it, but Judge Bouvier, he gave basically a definition of common law. It's the best definition I've ever heard of common law. But that's good for you to understand the definition. But I will promise you, I will get it and I will bring it up. All right, with that, let me just pause right here and let me check with the chat real quick. Can't wait till you actually go through the courses. All right, a motion to dismiss and affidavits. We are not slaves and we will protect and serve now. What? A demand for dismissal to all the haters on this channel. Why you want to be a Fed? You're the enemy of this once great nation. I know that's right. I am God's Penny SBC. Remember, the court is not the building, the judge is the paperwork. That's correct. High Frequency Radio. Peace to the gods. I appreciate that. Appreciate that. What else we got? Leave my family alone. All right. I got 6 queens. Okay, I'll answer a couple of questions in the chat real quick. Super chats get answered first. I appreciate the donations. I didn't get the names of the people who donated, but I appreciate that. Oh yeah, me and Camp. Let me, you know what? I'm going to do that on a separate, I'm going to do it today, but I'm going to do it on a separate video. I'm going to do it on a separate video. I'm going to do it on a separate video, but I'm going to do it today. But I'm going to do it on a separate video. Because that needs to be, that needs to have its own video. It needs to have its own video. The 3-level chess, yeah, BBB versus Notary Public. I think the Better Business Bureau is a very good, I mean, the way they got it set up, it's an administrative process. Man, when I did that, it's very effective. It's very, very effective because they're a witness. It's all about a witness. And they send the correspondence like a notary will. They send it to them, okay, and then if they answer, they have to answer. But it's on the public record for everybody to see. It wouldn't hurt to do both. Use the notary and use the Better Business Bureau. I think you go over there and check it out. You'll see what I'm talking about. You'll see what I'm talking about. I am put up forms and pleadings. I appreciate the $4.99 I-57192 public notary. What is your take on quo warranto? Quo warranto means by what authority? Quo warranto is a common law. It was common law, and I don't think it has any application under this commercial jurisdiction that they're operating under. But quo warranto means by whose authority. Okay, and it's like, well, it's the same thing when you go in there, you know, maybe a bill of particulars would probably be more ideal. You know, just my opinion on that with a quo warranto. And I see somebody said earlier about sui juris, which means by one's own right, how you file something. What books you reading lately? I'm reading Me and Camp. I'm studying everything right now about socialism, Marxism, and communism, and what's going on, because I think we are about to go into a World War III and people are taking it lightly. Fiduciary for mental disabled adult. My son is making horrible financial decisions for us. Woo. Man, with all this information, I don't know what to tell you. The internet is rife with a lot of good information for you know, finance. You know, what's really good for situations like that is when you start associating, you know, going to conferences. Try to get him to start going to like Grant Cardone has a conference, and you know, some individual like that. It's good to go to those things because you get around like-minded people, and it has an effect on your thinking. You know, that's really what those conferences, really what they do. It allows you to go around a certain mindset. When you can't find that mindset, your friends don't think that way, you know, and you're looking for people to be around that have a certain mindset. Start going to these conferences, man. Start going to those things. It's real good for that. Can a notary send an interagency subpoena ducis tecum? Interagency? I don't see why not. I mean, if you're subpoenaing, you got to serve somebody with a subpoena. A service of process. I don't know, do notaries serve process on? I think you need a process server, a sheriff, or somebody like that. I would probably use a process server, not a notary. But I'm not really sure what you mean when you say interagency. I'm not familiar with that. As a polyglot, I can certainly help on the pronunciation by request only. I don't know what that means. Can you do slightly more advanced for intermediates? Yeah, I can. I will. Who put your son in charge without putting him in law school? I don't know who you're talking to. Thanks for answering. Much appreciated. I don't go to the conferences. They come to me. Okay. All right. The ownership is the ship. I think you shouldn't. Everything about success is about who you associate with. Bad association spoils useful habits, as it says in the Bible. So you make as much money as the 5 people that you hang around all the time, because we're talking about the principle of vibration. So your vibrational frequency is a match with whoever you associate yourself with. This is why even in law, they have guilt by association. I got somebody I'm dealing with right now. They're getting charged with almost like a murder charge. And it was basically built off of guilt by association, because she didn't do anything, you know. But you can be just hanging around the wrong people. Yeah, you are sharing that vibrational frequency. Birds of a feather flock together. So if you want to change your condition, one of the first things I would suggest that you do is change your association. That's one of the first things you do. Mac $4.99 in California. The Secretary of State Office refused to give us official bonds of executive branch employees, even though their code says they have them. Well, if they have the code, you present the code. You present the code to them. They got to follow the code. All you do is write a letter certified with an affidavit of mailing, citing the code section that tells them they have to provide that information. Now you have proof that they have violated their constitutional oath. And now they are not any longer immune. Now you can take action against them, because now they're operating outside the ambit of their delegated authority, because they're not doing what they've been told to do. They're doing what they want to do, which means they're operating privately and not publicly. Simple. I'm associating with you and 4 others. Okay, great. Good afternoon, Brother Yusef. I'm getting off work, jumping in the live. Peace, everyone. Great. I'm having issues too. No response yet. Like, a lot of times y'all have response because y'all don't know how to correspond. I got 2. If you go to SBC University, get back on SBC University real quick. On SBC University, on the dashboard, I got in my archives. These are archives of webinars I conducted. I got this right here, corresponding with public officials. This is one of the best webinars I conducted, because in there I show you how to draft your correspondence, how to talk to these people, how to write, and all of these kind of things like that, how to actually put documents together. Because that's a problem with a lot of people. You don't know how to write documents. You don't know how to correspond with a public official. You don't understand what constitutes evidence. They understand it. That's why they do. That's why they don't answer you. Hey, look at this fool. He don't know how to motherfucking even he don't even know how to force me to do anything. If they have a duty, that's the key. I hope you look that word up. Duty. If they have a duty to act, then yeah, they're required to do it. And it needs to be in writing. For a matter to be resolved, it needs to be expressed. The spoken word flies out the window. The written word remains forever. That's in the what? Back of the what? Black's Law Dictionary. That's where I found that. Man, I cited the code. They still didn't do it. I can show you. Okay, you write it in writing. You don't have to show me anything. If they didn't do it, if they didn't do it, and you sent them a letter, I'm requesting such and such information. If you're not required to give me this information, can you please cite your authority to do it? You need to contact risk management and file a claim against them. We have some people over here that are they're an imposter. Because here's the code section that requires them to do something and they're refusing to do it. You don't need to show me what you sent. You need to show me their response. And you need to show me how you sent it to them. Did you send it certified mail with an affidavit of mailing from a notary as a witness? All evidence requires 2 witnesses. That comes from where? The Bible. 2 witnesses. The courts is based off the church. The original judges was the Levitical priesthood. It's a priesthood, all right? That's why everything is affidavits. Who you swearing an affidavit to? The creator of the boundless universe, God. They used to come into the courtroom with the Bible. You had to swear, you put your hand on the Bible. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. And they teaching y'all to eschew the Bible, to deny the existence of a God, to act in the capacity of a heathen. How much comes to the table? $49, everything I'm showing you. Everything I'm showing you. But somebody's still going to complain about that. This nigga over there charging $49, y'all. And $100, it ain't going to be that I charge $49 that's going to make the haters mad. It's going to be that I charge $49 and 100,000 people signed up. That's what's going to make them mad. That will make them mad. It's like, God damn, this nigga charged $49. How much did they bring out the calculators? God damn, this nigga, he charged $49. How much is this, man? This nigga charged $49 and 100,000 people signed up. Man, this nigga made $4 million. Somebody gonna be pissed off, you know. They're gonna be mad as hell. I can't help it if I'm a good businessman. I can't help it. You know, I pride myself on being a good businessman, knowledgeable, giving value, understanding the meaning of giving value. Because if you're going to charge people for things, you have to give value. And usually, the smartest thing you can do as a businessman is give more value than what you're charging for. Give the people more value than what you're charging for. You can never go wrong doing that. Yeah, you can show me your responses via email, yes. Shaking my head, that's crazy. $49 for all this knowledge. If tour knowledge was your wealth, then it will be well earned. Tort claims for trespass on public official. That's, tort claim is a private claim. Torts fall under what? Private law. So a tort is a private, it's on the private side. So yeah, that would be appropriate. After doing the SBC process, are you doing business trust to hold the administer the estate? Yes. Okay. All right, I'm doing one tonight. All right, I'm going to get off now. I've been on for a minute now. I'm going to come back and do another show. I got to take care of some business. Hopefully you were able to glean some nuggets of truth, learn some things, be able to perceive some things when you go into the courtroom, understand everything is not what it seems. There's a light show that's going on behind the scenes. They're preying off your ignorance on a lot of the things that I'm talking about. And if you're going to go in there and you're going to argue, which a lot of people do, they like to argue jurisdiction, which I believe is a dangerous place to move because you are in their domain. As you can see, that's their domain. When you go into there arguing jurisdiction and doing all these arguments and making requests and all these things, the superior man stays in his own domain. All right. With that being said, I will catch y'all on the next one. Like, comment, and subscribe. Make sure that you hit the notification bell. That's good for the analytics of this channel. Yes, Kelly, you can. You have to get on. Right now, I got a backlog of people, man, and it's $500 for an emergency consultation. If you go, I'm like 2 months booked. I'm 2 months booked out. I'm just keeping it real. All right, so with that being said, I will catch y'all on the next live. Peace to the gods. I'm out.